Well, hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. I am your host, Uncivil Law, a licensed attorney in both Texas and Virginia. It is June the 1st of 2023, and we are here with all your legal news happening in your world so that you can be better legally informed. Our story today takes us to the Amazon Ring doorbell, a very popular device in the United States where people have this on their homes and apartments so that they have ability to see what's happening outside their house and communicate to people outside their house via the doorbell. Has a little speaker on it and microphone so they can hear and talk. Also very helpful in particular for catching people who are stealing packages, and also very popular with the police, of course, because it gives them a surveillance tool that isn't subject to normal Fourth Amendment concerns. Because if it's not your camera, you don't have a Fourth Amendment concern, right? So if they're trying to find something happening out in the world that isn't about you, but just about a thief in general, right? The thief doesn't have a Fourth Amendment interest in someone else's camera, so they can't bring a suppression hearing relating to someone else's camera because it doesn't really matter how the police came into that information. Even if it came into it illegally, it didn't concern you. So, very popular for a whole bunch of reasons. Also, sometimes people use these kinds of devices inside the home for monitoring things going inside the home as well. Well, regardless of how you use these devices, Amazon is paying a $6 million settlement to the FTC that dealt with employees and third party contractors having unrestricted access to videos of people's homes so that people who worked for the company could just see whatever cameras they liked inside your home, outside your home, of anything that might pass their fancy or their interest, perhaps of a more adult nature. Maybe it's some of the things they were looking for. And Amazon is like, oh, yeah, we probably violated our consumers' privacy and lied to them a little bit about how we were dealing with their data. So we have to pay a settlement. Let's learn a little bit more about this settlement. The Amazon owned smart doorbell Ring company has agreed to settle a lawsuit brought by the Federal Trade Commission relating to privacy and data security. Ring will pay $6 million, which, of course, to Amazon is a rounding error. Do they even notice? I'm sure it's just a loose change they found in their sofa cushions at their corporate headquarters, but we'll pretend like it makes a difference. They will pay $6 million to the FTC and implement a new system for data security as part of the settlement. I already feel more assured. I already am feeling like my data is going to be taken much more seriously because maybe next time Amazon will have to pay $12 million. Ooh. The surveillance company, which was acquired by Amazon in 2018 at what was at the time a $1 billion deal, and of course is worth more than that now. Is used by millions as a form of security, but of course the FTC says employees had unrestricted access to the footage. So Ring wasn't always an Amazon company; it was acquired by Amazon, and they have gone on to great success with the devices, and people are able to just use them whenever they want, willy nilly, no problem. A Ring spokesperson said that Ring addressed these issues on its own years ago, well before the FTC began her inquiry. We're not sure what the FTC was concerned about. We solved this problem long ago. Why are they all up in our hair? While we disagree with the allegations to deny violating the law, the settlement resolves this matter so we can focus on innovating on behalf of our customers. Query exactly who their customers are in this scenario. Are their customers the people they sell the doorbells to, or do they have other different customers? Who exactly is the customer is a good question. In one instance, a Ring employee viewed thousands of recordings from at least 81 cameras owned by women. Only after a supervisor noticed that the male employee was viewing videos of only pretty girls did the supervisor escalate the report of misconduct. Only at that point did Ring review a portion of the employee's activity and ultimately terminate the employment. So, yeah, perhaps unsurprisingly, some people are looking for, people that attract their fancy or people doing perhaps misdeeds that are not necessarily illegal or, maybe a little bit salacious. And, some people got caught up on this. Yeah. The FTC further alleged that employees of third party contractors who happened to be working in Ukraine also had access to company footage with little restrictions. So, just not sharing our data with our US partners. How about just anywhere in the world? This isn't necessarily the ones we caught were in Ukraine. Was this a Ukraine problem? Absolutely not. But we will pretend like it was. Because, of course, it's the same problem everywhere. In 2022, a US Senator probe found evidence that Amazon was handing over footage to police without consent of owners of the cameras, which isn't necessarily illegal, of course, but might violate the privacy guarantees that Amazon or Ring made to the customer. So, not necessarily disclosing to the customer that we're sharing all this wonderful, wonderful information with law enforcement. Law enforcement loves it because there's no Fourth Amendment issues. It might violate the customer's privacy. So the customer might have a lawsuit against Amazon, but the customer has no complaint against the police. And the person who the evidence is used against has no complaint because they have no privacy interest. Of course, this is assuming that the camera isn't capturing them in their own home or in their own yard or in their own place, right? So we're assuming in this scenario that it's some third person's camera, which of course is way, way more typical. But if it's just a random person's camera, if it's not your camera and they're capturing you in a place that you don't have an expectation of privacy, which is basically everywhere in the world but your home, pretty much, then you don't have any complaint. Amazon over here says we'll continue to prioritize privacy, security, and user control as we pursue and improve technologies to help achieve our mission of making neighborhoods safer and also gaining data and also monitoring our users and also figuring out how people interact in the world so we can sell to them better and other things too. But also safety. That's what we'll sell it on. Think of the children, and we won't tell you about the other part. Okay, that's just all super. Thus, that brings us to Amazon having to pay $6 million. And Amazon's over here like, will you take loose change that we found in our sofas at our corporate headquarters? Because Amazon is $1 trillion company. And $1 million is a millionth of a trillion. So it's not very much money. It would be like less than a cent to you and me, right? I'm assuming in this scenario that none of us are multiple millionaires. But hey, if you are a millionaire, this would be like $1 to you, right? Or maybe like $3 to you. Ooh, right? So if you're a millionaire, this is like $3 to you. If not, then maybe a couple pennies. So Amazon probably isn't sweating it very much, but it's okay, people. They've made reforms, and you can trust in those reforms because if we didn't make the reforms, we might have to pay more next time. And maybe next time it won't just have to be the couch cushions. Maybe next time we'll have to go to the change drawer and the little bowl that we keep changing in purpose and get the money from there. So we are definitely making the reforms over here in Amazon. And that for the moment brings us to the end of discussion of this story. Well, good morning, everyone, and welcome, of course, to Uncivil Law. I hope all of you are just having the most wonderful day. As always, we wish you nothing but wonder and joy here on Amazon or Uncivil Law or whatever the name of this channel is. Uncivil brought to you by Amazon, maybe. I don't know. They haven't bought out the channel yet, but maybe someday. Maybe someday. We'll see. We have pushed the button. Thank you, Castrol, for reminding me to push the button. I appreciate it. We have 3 U.S. Supreme Court decisions today. We will be going through them in turn. We will do a Supreme Court story, and then we'll do a different story, and then go back to Supreme Court, and so forth and so on. And we'll see how that goes. So all the good things. We now have polls. We have a poll in the chat today. We have a poll in the community tab. We will try to post a poll in both places every single day, adding to my increasing workload to do another thing. All the rest of it. Great. Good morning from wherever you are in this wonderful world of ours. Let's turn our attention to the United States Supreme Court. For today's US Supreme Court case, we bring our attention to Glacier versus International Teamsters. This case deals with unions and unions' ability to protest and say that they don't want to work and strike, and the union's responsibility for damages that occur during that strike. So the United States law protects unions and protects union rights under the Federal Labor Relations Act. And if there is a union, they might have the ability to strike. What if damages occur during that strike? Who's responsible for that? This case deals with that, and as a result, somewhat changes the calculus for unions when they're considering striking. So let's learn a little bit more about this change in labor relation law and unions' abilities to protest wages and working conditions. Let's learn a little bit more about this. Have I heard about the Moses Roses Bar in San Antonio? The city's trying to take it away via eminent domain. For what reason? Would be the next logical question. What do they want to do with the land? Are they trying to take it away because they want to like put a highway through it or a school or what? So that they're trying to take it away by eminent domain only gives me half the information I need. But no, I haven't heard about it, so I have no thoughts. They want to build a theater? Like a public theater? Like a community theater? That could be cool. That might be okay. Yeah, if they give fair value, that might be fine. Okay, moving on. Glacier Northwest delivers concrete to customers in Washington state using trucks with rotating drums that prevent the concrete from hardening. I'm sure you've seen these trucks on the roads many times with their spinning tumblers in the back, right? Keep the concrete in a nice liquid state so that it doesn't, solidify in the truck. And then it's ready to go and be poured when we get there. Fantastic. Concrete, of course, is perishable, and even concrete in a rotating drum will eventually harden, causing significant damage to the vehicle. So this merely delays the process of hardening by not letting it sit. But the liquid is, of course, coating the inside of the drum, and it will start to harden. And eventually, it will harden given enough time. So we have to get it to the delivery site and out of the truck as fast as possible to avoid this from happening. The truck drivers in question in this case are members of a union. After a collective bargaining agreement between Glacier and the union expired, the union called for a work stoppage on a morning it knew the company was in the midst of mixing substantial amounts of concrete, loading the batches into trucks and making deliveries. All right. So the union over here has a bargaining agreement. They have a contract with their employer, right? These contracts tend to run for a period of time and then expire, and they have to be renewed. That's typically how they work, although your mileage, of course, may vary. So they're in a negotiation relating to the contract between the union and the employer. The negotiations are breaking down, which is, of course, not uncommon. So they're like, okay, we're going to strike in response to this. When are we going to strike? We're going to strike on a day when the company really, really needs us, right? That will create an incentive for them to settle the strike faster because they really, really need us, right? So we're going to use our knowledge of the company to try to put their feet to the fire a little bit. All right, so that's what we're trying to do. The union directed drivers to ignore the company's instructions to finish deliveries in progress. We already have the trucks full of concrete. Please deliver them. No, we're not going to do that. Okay. At least 16 drivers who were already set out for deliveries returned with the trucks. We didn't do the delivery. By initiating the emergency maneuvers to offload concrete, the company prevents significant damage to trucks, but all the concrete mix that day hardened and became useless. So we were able to prevent most of the damage to the trucks, thankfully, but the concrete itself spoiled because it has already been mixed. It was going to harden. It was just a matter of time. The trucks help delay that process, but don't stall it. So we were able to get most of the trucks back and the concrete out of the trucks, but the concrete itself spoiled, and there was a lot of it. So there's a lot of expense in that because, there's material in that stuff. The company over here sues the union for damages related to the product that is no longer usable, claiming that the union intentionally destroyed the company's concrete, and this conduct amounts to conversion and trespass to chattels. Conversion is the civil version of theft. Conversion is where you take someone else's property and deprive them of property. So that's what we're doing. And trespass to chattel is, it was our stuff, you took our stuff. So similar theories, right? Conversion is you took it from us in a permanent way. Trespass is you took it from us in perhaps some sort of temporary way, but related theories of the tort. The union moved to dismiss the claim on the grounds that federal law preempts. So you're trying to sue us in state law for basic state level torts, basic state level stuff. But hey, this is a union activity. And as I mentioned, unions are protected by federal law. So they say federal law preempts the issue. While federal law generally preempts state law when there is a conflict, the law requires that state law apply even when there's only, or rather that federal law apply even when there's only arguably a conflict. So federal law, of course, dominates this concern, as you would expect. The normal rule is that if there's a conflict, federal law wins. This particular federal law is a little bit more specific and says not only if there's an actual conflict, but even an arguable conflict. So the court doesn't necessarily need to find that there is in fact a conflict, and in fact, only that there is some tension between the two, right? So normally in federal law, if there's merely tension between the two, we may very well resolve this in favor of state law because there's not preemption, right? We'd actually have to get into it. But this federal law says, don't even do that. If there's any potential conflict, federal law wins. Okay, fine. In the union's view, the federal law, which protects rights to self-organize, form, join, or assist labor unions, and to engage in others for the purpose of collective bargaining and mutual aid, at least arguably protects the driver's conduct, so state law lacks power. I mean, okay, that isn't completely illogical given this rule, right? So we have a right to engage with others in our mutual aid relating to collective bargaining. This is related to collective bargaining, and we are doing this activity for the purpose of collective bargaining. So the idea that federal law preempts, given this language, is not wholly insane. So we're going to try to give that a shot. The Washington Supreme Court agreed with the union, reasoning that the relevant federal law relating to loss of concrete products was preempted because the loss was incidental to the strike. So the strike itself is protected. This is concerted activity for the purpose of bargaining. It's incidental to that purpose, so federal law preempts. So your remedy, if anywhere, is federal law and not in state law. So what does the Supreme Court say? Supreme Court disagrees, saying that the National Labor Relations Act does not preempt tort claims alleging intentional destruction of property. So whatever your union protected rights are when it comes to the mutual aid and activities in concert thereto does not include this. So you can go forward in state law. The union is responsible for damages under state law. The parties agree that the relevant federal law protects the right to strike, but the right is not absolute. The National Labor Relations Board has long taken the position, which the parties accept, the relevant law does not shield strikers who fail to take reasonable precautions to protect property from foreseeable, aggravated, and imminent danger due to sudden cessation of work. So we already have some precedent on this issue. Yes, you are allowed to strike, but you're not allowed to strike in a way that causes damages to the property of the employer. So you have to strike in a way that isn't going to cause harm to the property and equipment of the employer. Given the undisputed limitation on the right to strike, the court holds the union has not met its burden as the party asserting preemption to demonstrate that the relevant law arguably protects the driver's conduct. Accepting the complaint's allegations is true because, of course, this was all in a motion to dismiss, so we don't know whether or not any of this is true yet because we didn't get that far. So assuming it's true, the union did not take a reasonable precaution to protect the property from imminent danger resulting from driver's sudden cessation. The union knew the concrete was highly perishable, that it lasts only for a limited time, and concrete left to harden would cause significant damage. So, They are in the business of the concrete, so they have some knowledge when it comes to this. This is not a surprise to them. The union, nevertheless, with this knowledge, coordinated with truck drivers to initiate the strike while it was in the midst of batching large quantities of concrete and delivering it to consumers. So, according to the allegation, the union particularly chose a time when this effect would be maximized. So, rather than taking steps to mitigate harm, they took steps to aggravate harm to the company, presumably in an attempt to force the company's hand when it came to the bargaining. But either way, regardless of their motivations, they chose a time when the company and their damages would be particularly enriched rather than mitigated. So they didn't pick a time when, like, there were, we'll strike at midnight. They didn't do that. It was like, we'll strike when all the trucks are already full. And, that's not quite fair to the company over here. The resulting harm to the equipment, because there was some, and the destruction of the concrete was both foreseeable and serious. The union thus failed to take reasonable precautions to protect against the foreseeable and imminent danger. So, you are employed by your employer. You have a duty to your employer. So, while there is no general duty by general members of the general public, there is a duty in this situation because they are employed by the company. The nature of the duty comes in the form of the contractual obligation. By taking on the obligation to the employer, you have a duty to the employer. Now, of course, you also have rights unto yourself. So that duty is not, completely all-encompassing. But you do have some affirmative obligations that you took on voluntarily by contract. And one of those is to not cause purposeful harm to the employer, which you just did. So we can hold you responsible because in this situation, your failure to act, assuming that's what this is, failure to act, right? We didn't do anything. We just simply walked off the job. Well, your failure to act can be held against you because you do have an affirmative duty because of your employment contract. So not so much with that defense. The union's efforts to resist the conclusion that the relevant law does not arguably protect its conduct is unavailing. First, the union emphasizes that protections of the right to strike should be interpreted generously. Okay, so we should have the right to strike for our collective bargaining rights, fine. But the right to strike is not absolute, and the court must analyze whether the right to strike exceed the limitations of the conduct. So yes, you do generally have the ability to stop working. You do have generally the ability to quit, but there's some obligation to not cause massive harm to your company while you're doing that. Especially when it was pre-planned out in advance to do it at this time. So we're not even in a situation where like a worker got completely fed up, and this was the last straw. And they're like, I quit, right? Because you have a right to quit, just as they have a right to fire you, right? This is the last straw. I'm leaving right now. Does an employee in that situation have a duty? Don't know. We're not trying to speak to this issue right now because maybe they have a right to quit. This isn't quite that situation because this was planned out in advance, right? We will strike exactly at this exact moment when it is exactly maximally harmful as opposed to some other time. And we will do it in concert together to even cause more harm. So does an employee have the right to literally quit at any moment, no matter what would happen to the employer? Don't know. Does a union have the right to quit or strike en masse in a way to purposefully cause harm to the employer en masse? No, that's a little bit much. Can't do that. Second, the union argues that workers do not forfeit their rights simply by commencing work stoppage when the loss of this products is foreseeable. But this case involves more than that. So they're like, okay, we're not responsible if only problem is that some product gets spoiled. But there was more. Given the lifespan of concrete, the company could not batch it until a truck was ready to take it. So they can't make the concrete until the truck is available. Because once they start mixing it, the clock is running. So they only mix it when the trucks are available. By reporting for duty and pretending as though they would deliver it, the drivers induced the company to make the product. They wouldn't have done it if the trucks weren't available. You showed up pretending like you're ready to go. And they started to make the product and we're like, we're not going to deliver it. Okay, that's not really fair. Then they waited to walk off onto the job until the concrete was actually mixed and already in the trucks. Chose that maximum impact time. In doing so, they not only destroyed the concrete, but of course put the trucks themselves at risk because, there's going to be some potential harm that way. Third, the Supreme Court acknowledges that the union's decision to initiate the strike during the workday and failure to give notice do not themselves render the conduct unproductive. So it isn't an issue that we decide to strike while work was happening. It isn't an issue that we didn't give the employer notice. That isn't the problem, right? So is the employer entitled to notice? Not necessarily. Are they entitled to have you strike on a weekend as opposed to a weekday? No, not necessarily. That's not the problem. There's a general right, of course, to stop and strike or stop and quit. So that's not the problem. Still, these actions are relevant considerations in evaluating whether the strikers took reasonable precautions when the harm was imminent and the danger foreseeable. So it isn't that you quit during the middle of the day. It's that you quit in the middle of the day at a time you knew it would harm the company the most when the trucks were already loaded, when you showed up pretending like you were ready to load the trucks and ready to go. So that was the problem. Here, the union's choice to call a strike after deliveries had loaded the concrete in the truck strongly suggests it failed to take reasonable precautions to avoid foreseeable, aggravated, and imminent harm. Finally, while the union maintains the drivers took some steps to protect the trucks, the union concedes the relevant law does not arguably protect the actions if those actions posed a risk of harm. So yes, we did take some steps to mitigate the harm, but the relevant law does not protect us if there is a risk of harm. So that the harm didn't necessarily occur is not necessarily the issue. The fact that we put things at risk knowingly and we're acting in a reckless way, the reckless nature of the conduct is a problem. You can't act recklessly, basically. Given that the company alleges the union took affirmative steps to endanger property rather than reasonably mitigate, the relevant law does not arguably protect the conduct. In an 8-1 decision by the US Supreme Court, with Justice Jackson filing a dissenting opinion. Thus, that brings us to the end of this case of Glacier versus Teamsters, in which Glacier had a problem. They're a concrete mixing company. The Teamsters showed up with their trucks, purportedly ready to go for a large job. And the company was making very significant amounts of concrete that day. And there were a lot of trucks. And then the trucks got loaded. And then the drivers started driving. And then they're like, we're not going to finish our deliveries unless you meet our demands. Fortunately, the worst of the damages to the trucks was avoided. Unfortunately, all the concrete that was made was lost because it is a product that can only remain viable for a certain amount of time before it cures, and all the concrete cured. So there was a loss of product, as well as some equipment damage. The Supreme Court says that yes, there's a right to strike. Yes, there's a right to quit your job. Yes, you have collective bargaining rights, but you can't do it in a way to deliberately inflict pain upon the employer in a way that causes harm to the employer. So you have to do this in a way that isn't trying to create massive harm. So you are responsible for damages, at least in this scenario. How far does this scenario go in terms of damages will have to be decided. But the basic thrust of it is that the union is responsible, at least for the foreseeable damages. And so that unions might be well incentivized to, for example, give the employer notice in advance that they're going to quit at a certain dates, because then with that knowledge, presumably there would be no damages because the employer could mitigate their own risk or otherwise choose times to strike that will mitigate this loss. So how this will be teased out in the future as it relates to union activity will have to be teased out. But for the moment, that brings us to the end of discussion of this case. Push the button. Yeah. Push it. Push it. Push it real good. Do, do, do. Catherine gets a prize. Springstorm gets a prize. Kit Kat gets a prize for reminding me to push the button. Okay. Let's go to the next case. Turning our attention to marijuana, the law is becoming more and more favorable in various states relating to marijuana, and Arizona has ruled that various marijuana sales can be expunged from previous convictions. What's in the can? Coke Zero. In addition to making marijuana sales legal in the future, many states have made convictions in the past retroactively not illegal. So, of course, there is the power to pardon, which state governors sometimes have, depends on the state in terms of how that works, whether it's the governor or some other board that can do it. But also, sometimes it's the legislature themselves, because they can retroactively make something not illegal. And so we are in that kind of situation where these sales can be expunged. So let's learn a little bit more about how this turns in marijuana as it relates to Arizona. Let's get started with this. Some convictions for sales are eligible for expungement under a relevant law, which legalized marijuana for adult use according to the Arizona Court of Criminal Appeals. This will allow people who have their convictions to mitigate the impact on involvement with the criminal legal system, which affects minorities at disproportionate rates, according to the lead attorney and program manager for Reclaim Your Future campaign. In an opinion for the three-judge panel, the relevant judge reversed a ruling from a lower court judge that denied expungement of a man's 2014 sale conviction. The appellate court ordered the trial court to grant the expungement petition. So it's like, hey, does this law that we passed go backwards in time? To the extent it's making things less criminal, to the extent it's making penalties less, you can go backwards in time, right? Ex post facto only applies if we're making things worse. If we're making things better, retroactivity is fine. So, did we have retroactive effect in this law? And apparently the answer to the appellate court is yes. When the relevant law was passed, which legalized adult use of marijuana, there was also a part of it that authorized expungement for adults who were previously convicted of using or possessing amounts of drugs. So, hey, how about the use? How about possess? If it's legal now, as far as we're concerned, it was always legal. It was always legal. So all those convictions go bye-bye because now we're making it retroactively legal. So all those criminal penalties go away. So that would mean as of 2021, anyone who had been arrested, charged, or convicted of marijuana possession or use could expunge the records as it relates to any convictions or sentences. So we wipe all those convictions off the books. The eligibility for expungement, according to the new law, includes those convicted of possessing, consuming, or transporting 2.5 ounces of marijuana or less, possessing, transporting, or cultivating 6 or fewer plants for personal use, and possessing, using, or transporting paraphernalia. So as to which laws we are going to retroactively say were never illegal, these are the ones that we're saying. We have made a decision. These are the ones we want to strike off the books. Fantastic. Let's go do that. Just 3 days after this became law, the relevant attorney's office petitioned for the man's conviction to be expunged on his behalf, but the trial judge denied the petition for expungement, ruling that the law prevents expungement for sales-related offenses. So use, yes. Possession, yes. Sales, well, does the law contemplate that or not? The trial judge says no. The appeal court says yes. The appellate court says yes, even after the Arizona Prosecuting Attorneys Advisory Council submitted a brief asserting that expungement statute ambiguously excludes possessing for sale offenses. Well, that's not apparently how the Court of Appeals reads it. So apparently they think unanimously it does cover that territory. The appellate judges concluded that because transportation is now eligible for expungement, And because transportation of marijuana for personal use has not been a crime since 1987, voters must have meant to include transportation of marijuana for sales to be expunged. So, you know, okay. So we made the transportation of these small amounts legal. We said expungement of use or possession, but because it's not been illegal since 1987, we think that the voters really meant to include this as well. So that's what we think. Today's decision is a great embodiment of the will of the voters who elected to undo harms caused by over-policing of marijuana laws, the people said in a statement. There are many people who are charged with for sale offenses beginning before the passage of the relevant law, even when they had minimal amounts of marijuana, because other factors led officers to assume the person was some sort of dealer. So yeah, whether or not you are transporting for intent to sell, of course, can turn on quantity, but need not turn on quantity, right? Even if you have small amounts, that could be intent to distribute if other factors are present. So maybe that was what they thought, and that was the issue. The state and the cannabis industry is now making millions on marijuana sales. So it's fortunate that people who we believe to have committed a sales-related offense will now benefit from this expungement. So that's what the appellate court seems to think, and that is what's happening in the great state of Arizona. In the relevant court case, the individual was arrested in 2014 for possession of about 2/3 of an ounce of marijuana and charged with possession for sale, among with possession for drug paraphernalia. So only 2/3 of an ounce, but we think that you are a drug dealer as opposed to merely a user. As part of the plea agreement, the man pled guilty to solicitation to commit possession of marijuana for sale, and also which was a felony, but later was lowered to a misdemeanor after he completed prohibition. So that's what we were convicted of, but that conviction will now go away thanks to this relevant law. Thus, that brings us to the end of the case for the moment, dealing with Arizona and sort of interpreting their own state statute here. And Arizona says that, yes, the voters intended this to include transportation as it relates to small amounts of marijuana. So that is what they think the relevant law is that the Arizona voters passed. So that appears to be the judgment for the moment. Unclear whether or not further appeal is contemplated, but that is good news, at least for the moment, of citizens of Arizona, and also some good news for citizens of other states as well, because, of course, other states are increasingly relaxing and expunging these settlements, these old convictions. And one would imagine it's only a matter of time before it eventually comes nationwide. Some states, like my own Texas, are being somewhat resistant to this change, but eventually, one would think that they would join the fold as well. But we will have to see how that waits for another day. And at least for the moment, that brings us to the end of discussion of this case. Thank you, Kit Kat, for 5 gift memberships. That is extremely nice. Thank you very, very much for your contribution. Springstorm says to push it. We will push the button. Thank you very much, Springstorm. All right, let's do another Supreme Court case. The student loan case is going to come down, striking down student loan program, I'm pretty sure. Lisa Marie got him gift membership. Yay! All right, let's see what we got here. Let me just read this real fast. Mm-hmm. 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 Okay, all right, great. All right. I understand the case now. Okay. For today's U.S. Supreme Court case, we turn our attention to statements filed with the government relating to public companies. Public companies are required to file statements regarding their financial status and financial health, and these statements are, of course, part of the public record. These statements are at least used in part by people to make decisions as to whether or not to buy stocks in these companies. Of course, these statements that are on the public record must be true. And so the question is, well, if they're false, what is the remedy for a stockholder? What kind of things do a stockholder or some other person that has an interest in a company, what is their remedy and how do they go about showing their damages? So let's learn about this issue as it turns in the case of Slack Technology versus Pirani. Let's go ahead and get started with this. This case arises from public offering of a security, otherwise known as a stock, under the Securities Act of 1933. And the issue is what a public buyer must allege to state a claim. So in order to say I was hurt, what do you have to say happened? The relevant law requires a company to register its stock it intends to offer with the public with the Securities and Exchange Commission. You'd like to sell stock to the public, you have to register with the SEC. So if you have stock that you just trade privately, maybe not with the SEC. If you want to trade it publicly, the SEC would like to have a word with you. As part of the process, a company must prepare information that includes the information about the firm's business and financial health so that prospective buyers may assess whether to invest. So the public, they have to let people know what's going on with the company. The law imposes a strict liability on the companies with their statements with respect to material misstatements or misleading omissions. You can't lie to us. You can't hide the truth. You have to tell us what's going on with the company so people can be informed. In this particular case, Slack Technology, a technology company that offers a platform for instant messaging, conducted a direct listing to sell shares on the New York Stock Exchange. We'd like to sell our stock on the NYSE, please. Okay. As part of the process, Slack filed a statement for the shares it intended to offer in its listing. Under the process, holders of pre-existing unregistered shares were free to sell them to the public right away. So again, this is not exactly atypical, right? We're moving from a system where the shares are existing either between limited members of a company, so like a limited partnership or an LLC with multiple members, or some other arrangement where there is a relatively small number of members, small number of owners, and we're moving into a situation where those ownership shares are going to become public. So one of the things that you can do here in this particular situation, it says if you already own this stock in the company, one of the things you can do is you can list it for sale right away. So that's part of the deal. Under the process, holders of the pre-existing shares could sell them right away. The direct listing for purchase included 118 million shares that were registered and 160 million shares that were unregistered because of this change of status. We're moving from one kind of status to another, from less regulation to more regulation. So we have 118 million shares that are now registered, but we also have 165 million shares that pre-exist. So that's how we're dealing with that. Fine. Pirani, for his part, bought 30,000 shares on the date that Slack went public and later bought 220,000 additional shares. So he is buying some of these stocks. When the price dropped, Pirani filed a class action lawsuit against Slack alleging that Slack had violated the securities law by filing a materially misleading statement. So that statement that they filed as part of their ability to get onto the stock exchange was misleading. It contained falsehoods or it omitted things, and I paid a price based on the falsehoods. You tricked me. You've defrauded me. And so I'd like to sue you. Okay. Slack moved to dismiss, arguing that the complaint failed to state a claim because Pirani had not alleged that he purchased shares that were traceable to the misleading registration statement, leaving open the possibility he purchased shares not registered by means of this statement. So it only counts as fraud in the inducement if it induced me to the action, is the idea, right? These statements were misleading. The claim is, I bought the shares because you lied to me, right? Fraud in the inducement is basically what this boils down to. And Slack over here is like, but you haven't shown that you bought these shares because of the misleading statement. You might have bought the shares for other reasons, right? Did you even know the statement existed? Maybe you did, maybe you didn't, but can you prove that? What is the allegation here? The district court denied the motion to dismiss, but said, yes, you can appeal right away. The Ninth Circuit accepted the appeal and affirmed. So, no motion to dismiss. This case can go forward. Okay, so what is the right standard? What do you have to allege in your lawsuit? The Supreme Court holds the relevant law for the Securities Act requires a plaintiff to plead and prove that they purchase shares under the materially misleading statement. So if you want to argue fraud in the inducement, which is basically what this boils down to, I was tricked into buying the thing because of your misleading statement. You have to allege you did that, right? You have to allege it's because of the misleading statement. So if we want to break this down to a different example, right? A car dealership has an ad in a newspaper, and the ad is completely lying about this wonderful car they have for sale. All these wonderful things that are completely not true about the sale, right? You purchased the car. You claim you were tricked. Okay, but did you see the ad? Maybe you just drove by and just bought the car. So did the ad induce you? Can you prove it? You know, that you were induced by this as opposed to just walk by and be like, ooh, shiny, want. So if you want to say you were induced by the fraud, you have to, allege inducement by the fraud. That would be great. The relevant language authorizes an individual to sue for a misstatement or omission when the individual has acquired the security. The individual here, or Slack rather, argues the term, the security refers to security issued pursuant to the statement. So again, the nexus between the thing, right? It has to be tied. Otherwise, it doesn't count. Perani says the term may encompass security not registered under the statement. So just any old stock will be fine. While the word such usually refers to a thing that's already been described, there's no clear reference describing what such security means. So they used a word that refers to an antecedent, but there's no antecedent. This is like saying the apple without describing what apple in advance. If I tell you I want a apple, any apple will be fine. If I say bring me the apple, and there's no understanding between us of what apple I'm talking about, that's a bit of a problem. But that's basically what Congress did here. Okay, this applies to such securities. Which ones? We didn't bother to tell you. I want the apple, but I'm not going to tell you which one. Hope you get it right. Lord, Congress sometimes. So as a result, the court has to figure out what the hell you meant by the apple or such security because you didn't bother to tell us. What were you talking about? No one knows, but now we have to figure it out. Okay, so context might provide us some clues. First, the statute imposes liability for false statements or omissions in the registration statement. The statute uses a definite article to refer to a particular statement alleged to be misleading. And this way, it does seem to suggest the plaintiff must acquire the security under the document's terms. In other words, fraud in the inducement only accounts if I was actually induced by the fraud. Otherwise, I wasn't induced by the fraud. In addition, the statute repeatedly uses the word such to narrow the law's focus. For example, referring to such part of the statement that contains a misleading statement, suggesting that when it comes to such security, the law speaks to security registration under the statement alleged to contain a falsehood. Only those stocks that were purchased based on the statement count. Section 6 of the statute indicates the registration statement is effective only for the security specified therein. The statement only applies to stocks offered as a result of that statement. Other statements might issue other stocks. Which one did you buy it under? Right? Again, if we want to go to like a car dealership example, now I'm a car dealer with 10 different ads. Some of them are extremely misleading. Some of them are extremely false. Some of them are true. All right, I went and bought one of the cars. Okay, which one did I buy? Under which statement, if any of them? Make the allegation that, you knew about it in advance. The damage caps in the statute also make less sense with Perani's account of the statute. Collectively, the contextual clues persuade the court that Slack's reading is better. While direct listings like this are new, so this particular aspect of securities law is relatively new, in this particular aspect, but okay. The court's conclusion is not. The majority of courts for years have held liability extends only to shares that are traceable. So again, fraud in the inducement only applies if you were induced by the fraud. Resisting the conclusion, Pirani argues the court should read the phrase such security to include not only the securities registered under the defective registration statement, so not only those shares that said, we are currently offering 10,000 shares. Here's the description of the 10,000 shares. So should we read this statement only applying to the 10,000 shares? Pirani says no. Other shares should be read into it too. Okay. But also shares that would have some sort of relationship of some variety, whatever that would be. Pirani contends that but for the existence of the registration statement with respect to those shares, the unregistered shares would not have been eligible for sale to the public. So he said, if you didn't lie about those shares, these other shares, you couldn't have sold. You had to lie about those shares in order to offer these shares because of the nature of the law, right? But you only lied about these shares. You didn't lie about the other shares. Pirani does not explain what the limits of the rule would be, which is always a bad place to start, how the court might derive this from the relevant statute, or how any of it can be squared with various contextual clues, which suggest liability runs with only those shares that the ad talked about. For sale, 1 car. Other cars as well. For sale, 10 cars. Other cars as well. No. For sale, 100 cars. Other cars as well. No. Just the ones that were described by the ad. Okay. Otherwise, what were we talking about? Right? If I lied about if I lied about the car or 10 cars or 100 cars, what does that have to do with the price of tea in China? Pirani argues if Congress wanted to have liability to attach only to the securities that, the statement talks about, it could have borrowed language from a different part of the statute. So Congress could have been clearer, which, even the Supreme Court agrees with that much. On its own term, the argument also shows that Congress could have written the statute more clearly that liability attaches to any security or any security bearing some relationship. So yes, Congress could have been clearer in limiting liability. Congress could have also been clearer in expanding liability. Congress was a little unclear. So yes, they could have been clear the one way. They could have also been clear the other way. Things are a little ambiguous. We have to figure this out now. Finally, Pirani argues that adopting the broader reading will expand liability for falsehoods and omissions and better accomplish the purposes of the act. If it extended to all shares everywhere, then that would help companies be more responsible for lying. The court cannot endorse this purpose, nor is Pirani's account of the law's purpose altogether obvious. An alternate inference in the opposite direction is at least equally plausible. So yeah, maybe Congress wanted this to apply to all shares everywhere because that would expose liability, but maybe Congress didn't want that. Maybe Congress wanted it to only be about the things that were mentioned in the ad. So maybe they wanted it to be, if you lied about one car, your entire dealership sucks. But maybe they wanted it to only be about the thing that was mentioned in the ad, so that only those people that are harmed by the ad can sue for the ad. This applies in your local newspaper with your local Chevy dealer. This applies in the SEC. It's basically fundamentally the same. The court concludes the better reading requires the plaintiff to prove and plead that they purchased the shares because they were actually induced by the actual statements relating to these actual shares. Gorsuch delivering for a unanimous Supreme Court. Thus, that brings us to the end of the case dealing with Slack versus Pirani. Pirani bought some shares of Slack. He is sad the price went down. He believes that Slack made misleading statements or false statements in its registration with the SEC. He said, "Hey, you said you were a healthy business, and you're not a healthy business. You lied to me, and I paid too much." Well, Pirani over here has a problem because he can't prove the shares. He didn't even argue the shares that he bought were based on that particular statement. The statement says, now for sale. These 100 million shares, come buy them now. Did you buy those shares? Or did you buy different shares? Did you buy it because you were induced? Were you defrauded? Or are you just sad about the price going down? So Pirani over here has to say, yes, I relied on the statement. Those shares came from that, and he can prove that. presumably through a temporal connection, for example, based on timing would might maybe be a clue. But he has to actually do that. He can't just say, you lied about some shares and something, something, something else, magic underpants. So he has to actually show fraud that actually induced him. And that brings us to the end of discussion of this story. That's pretty easy. That's pretty easy. Push the button. Oh my God, Jeff wins the prize. Jeff wins a prize for push the button. Thank you, Jeff. Yeah, I feel like that's pretty easy. It's like, did you buy the car because of the ad? Did you buy the stocks because of the registered statement? It's fundamentally the same principle. Yeah. Okay. Yeah, okay. All right, what else we got? Okay. In firearms news, the Georgia Supreme Court has upheld a state law that allows people to bring firearms onto college campuses. This has been an issue in colleges for some time. There's an entire organization devoted to this called Students for Concealed Carry that focuses specifically on this issue, whether or not you can bring concealed carry onto firearms. Apologize. There's an entire organization called Students for Concealed Carry that focuses specifically on this issue, whether or not you can bring firearms onto college campuses. Of course, it goes perhaps without saying that most college campuses are somewhat sprawling affairs. And depending on exactly where they might be somewhat indistinguishable from surrounding areas of town, depending on where they are. If you're set in like a downtown area, as many colleges are, the college campus streets are just kind of the same streets as they are everywhere else. So college boundary lines are not necessarily easily delineatable. And also, crime doesn't magically stop at college lines. So some states say, yes, you can bring concealed carry onto our school campuses. And Georgia was one such state that said this. There was a lawsuit that says, no, you can't, but Georgia Supreme Court says, yes, you can. You can bring the concealed carry onto college campuses. So let's learn a little bit more about this. In 2017, the then governor of Georgia signed a law that would allow people to carry firearms onto campuses like Georgia State University or other public institutions. Since then, the legislature has decided gun owners didn't need to have a license to carry concealed, so that's also legal. So Georgia is one of the crew of, the unlicensed carry, constitutional carry crew. And so, yes, you can carry onto the college campuses because they said they are. Some students say that they don't like that rule very much. They prefer not to have guns on campus. 5 professors sued the state not long after the law went into effect, but the Board of Regents, of course, adopted a policy mirroring the law because the law is the law and says, yes, you can bring guns on campus. So the Board of Regents, which is the legislature, if you like, for the school, says, yes, we're going to mirror the state law because we're a state school and we're required to. And some professors over here, that's not fair. We don't like that law. So they tried to sue. And today the Supreme Court of Georgia said, no, go away. It's the law. Justice Elginton wrote, because the complaint shows the board adopted the gun carry law, the question is moot. So because the school says, yes, that's our policy because it's the law, the entire question is irrelevant. One student interviewed on the question says, I don't think it's a safe idea. Accidents happen, and we don't want to be scared coming to school or having to wear bulletproof vests just coming onto campus, so I don't think it's a good idea. Unclear how the student, goes about their life off campus, since concealed carry is lawful in Georgia generally. When they leave campus, are they concerned about this issue? Are they concerned as they go to their local grocery store or their local convenience store about this? Do they wear bulletproof vests everywhere else? No? Then why would it be a particular problem in colleges? Why wouldn't colleges just be the same as anywhere else? We're talking about adults. who are allowed to carry concealed. They would be allowed to carry concealed off campus in the exact same terms. They are carrying off campus in the exact same terms. When you go off campus and you visit places, there's people carrying guns all the time. Do you have problems? No. Why would it be a problem on campus in particular? Unclear. But whatever your complaint about the issue is, you lost. So, deal. Is Sandra leaving? Oh, or is Generous leaving? Someone's leaving. Alcohol? So there's no alcohol off campus? People don't drink off campus? Yeah. Thus, that brings our attention to the end of the case of the Georgia Supreme Court, which decided a state law that says, yes, you can carry firearms on the campus the same way you can everywhere else. Well, that's what the law says. So you can carry on the campus the same way everywhere else. Some professors had a problem with that, and the Georgia Supreme Court's like, no, go away. Because what's true on campus is true off campus. People do the same kinds of things on campus as they do off campus. And so, no, go away. And also, it's the law. So people were allowed to carry concealed on campus in Georgia, as they are in many other states, by the way. This is not a unique Georgia thing. Many states allow this, and there haven't been a whole roast of problems. So not sure why they thought it'd be a problem here, but in any case, they have to deal. And that, for the moment, brings us to the end of discussion of this case. Spring Storm wins the prize. Push the button. Thank you, Spring Storm. Little known fact, yours truly used to be state director in Virginia, regional director, and board of directors for policy for students for concealed carry. So I have some familiarity with this issue. That was a long time ago when I was a younger man. But 20 years ago, well, maybe not quite that long. Well, almost 15 years ago. 15 years ago, I was doing the students for concealed carry thing. So I have some familiarity with the issue. All right, let's see what's going on here. Okay. Okay. I instantly understand the issue. Let's cover this case. All right. For today's U.S. Supreme Court case, we discuss what it means to know something when it comes to submitting a false claim to the government. You can't lie to the government. You can't say things that aren't true. But something's only a lie if you know it to be false. That's the difference between a falsehood and a lie. You have to know what you're saying is false. Otherwise, it's not a lie. You're just mistaken. So what does it mean to know something in this particular context? How do you show knowledge? Whose knowledge is important? What is the relevant standard? So we're going to take a look at this case of United States versus SuperVal as it relates to this question. Let's get started with this. In this case, the petitioners have sued retail pharmacies under the False Claim Act. The False Claim Act permits private parties to bring lawsuits in the name of the federal government against those they believe to have been defrauded by the federal government. Excuse me, no. The False Claim Act permits private parties to bring lawsuits in the name of the United States against those who they believe have defrauded the federal government and imposes liability on anyone who knowingly submits a false claim. So this is one of those situations in which you can become the government. You get to sue as though you are the government. So these people suing are not strictly speaking in the United States, but they're acting in the name of the United States. And we've seen this also a matter of state law. California, perhaps most famous with this, going the furthest in this direction with their Private Attorneys General Act. Do you want to be the state of California? Well, good news. Quite frequently, you can be the state of California because the state of California lets you sue on damages that occurred to them. The federal government also allows this to a limited degree. And for basically the same reason, right? The federal government would like to know about the frauds happening. Now, of course, they have their own investigation mechanisms. They have their own agents. They have the FBI and everything else. But you know what? What if we had a bounty program? What if we had a bounty program? What if we said, hey, private individual, would you like some money? Would you like to be the US government? Good news for you. If you find that we've been defrauded and you tell us about it, you get money. Yay, money. So this is kind of like whistleblower in that way. This is similar in saying, right? By telling the federal government about the thing, and then the thing gets exposed, you get some money, we get some money, the crime gets exposed, everyone's happy. So we're trying to sue in the name of the federal government. We are the federal government. We're the United States. Let's go. Here, the petitioners claim that the respondents, SuperVal and Safeway, defrauded two federal benefit programs, Medicare and Medicaid. We are lying to the Medicare and Medicaid is the allegation. Both Medicare and Medicaid offer prescription drug coverage to their beneficiaries, and both often cap reimbursement for the drugs at the usual and customary rates charged to the public. So Medicare will pay for drugs. We're willing to pay the normal price. All right, great. But according to the petitioner, SuperVal and Safeway for years offered various pharmacy discount programs to their customers, yet reported higher value prices rather than discount prices. So SuperVal, Safeway over here, offers a coupon to its people. If you come, here's a nice coupon. Would you like cheaper drugs? Yes, you would like cheaper drugs. Here's a coupon. You can have cheaper drugs. But when we told the federal government what the price is, we didn't mention the coupon. So we reported the price without the coupon, even though we regularly offer coupons. So that is what we're doing over here. The petitioners also present evidence the companies believe that the discount prices were, in fact, their usual price. So they show that internally, they think the discount price really is the normal price. So this is really what the price is, but it's with a coupon. But this really is the normal price. So therefore, trying to prevent regulators and contractors from finding out about what is really the real price. So the real price is with the coupon. We believe that's the regular price, but we'll pretend that the price is something different when we tell Medicaid about it. In sum, the petitioners claim the evidence shows that respondents thought their claims were inaccurate, but submitted them anyway. We are lying to the federal government about the drugs. Okay, that's the allegation. Two essential elements of the allegation are falsity and knowledge. Right, that's what makes a lie. It has to be false. You have to know it's false. Otherwise, it's not a lie. It's just false. The district court ruled against SuperVal on the falsity element, finding that the discounted prices were usual and customary, and that by not reporting them, they submitted false claims. So the district court taking a look at this, things like, yeah, we did it bad. However, they grant summary judgment based on the knowledge element. So it was false, but we don't think that you knew it was false. So we'll grant you, SuperVal, relief that you didn't know. That's what we're doing. In a separate case, the court grants Safeway summary judgment on that same basis. The Seventh Circuit affirmed both cases, relying heavily on a previous U.S. Supreme Court case that interpreted the term willfully as it relates to the Fair Credit Report Act. So again, this kind of knowledge requirement. What does willfully mean? Right? Well, the Supreme Court has sort of defined that. And so we think that knowledge has that same sort of meaning. We're going to interpret the one for the other. Okay, as the Seventh Circuit read our relevant case law, the companies could not have acted knowingly if their actions were consistent with objectively reasonable interpretation of the phrase usual and customary. So what they say is that knowingly is objective, right? It requires what a reasonable person would know not what they specifically would know, right? So this is often a question in law. Whose frame of reference are we talking about? Is it that you knew or that people in general knew? What do we mean by knowledge? And the Supreme Court had previously said, well, what matters is the objective, not the subjective. What people know, not what you know. All right. Thus, the Seventh Circuit concluded the companies were entitled to summary judgment, even if they actually thought their discount prices were usual and customary based on this. $50 from Jules Buddha. Thank you very much. That's very, very generous, Jules. Thumbs up and prayer emoji. Been on the replay, clue to work. Have a great day, Kurt. I'd like to hear the dissenting opinion from Jackson, just to hear the reason behind it. Darn, now I'll go look at myself law. Well, thank you very much, Jules. Given time, maybe we'll take a look at that dissenting opinion. And I really do appreciate your super chat. That is very, very thoughtful. And I appreciate everyone who helps to donate to the channel and support the channel financially, because this channel does have a fair amount of expense behind it. And your contributions really, really do help. It makes a huge difference. And there's even more things I'd like to do, in terms of the channel, like, pay some people to help assist me, maybe, because it's getting a little bit burdensome and stuff like that. So I'd like to bring in even more revenue to make my life a little bit easier. So your contributions help substantially with the channel and the channel growth. Thank you very much. Also, it'd be nice to be able to travel some more, for the channel. That would be cool. Go visit some things. That'd be nice. And so all your contributions help a lot. Thank you. Anyways, where was I? The Supreme Court holds that the false claims knowledge element refers to a defendant's knowledge and subjective beliefs, not to the objective. That makes perfectly logical sense, because that's normally how knowledge works. So you have misinterpreted our law when it comes to knowledge. So as to willful, maybe we're looking a little bit more objective. But as to knowledge, what matters is what you know, not what some person knows, right? If you know, it's a lie. It's what matters. So what matters is your knowledge frame. That's normally how we do knowledge, so that makes perfect logical sense. The relevant texts and common law roots demonstrate that the knowledge element refers to the defendant's knowledge and subjective beliefs. The relevant law sets out a three-part definition of knowingly that largely tracks the common law. Actual knowledge, deliberate ignorance, or recklessness will suffice. You actually knew, you purposely blinded yourself, willful blindness, you purposely prevented yourself from knowing, so you knew, or recklessness, right? You behaved in a way that gave you some clues if you had only looked a little bit, right? So you actually knew, you wanted not to know, or the clues were all around you and you bothered not to look in a reckless way. So any of those things will be fine. Each of these turns on what the defendant themselves thought and believed. Actual knowledge refers to what the defendant actually knows. Deliberate ignorant refers to defendants who are aware of a substantial risk of falsity, but intentionally avoid taking steps to confirm. Willful blindness. If you put on the blinders, it's because you knew what you would see. And so, no. Reckless disregard captures defendants who are conscious of a risk, but submit the claims anyway. These forms of scienter track the common law fraud, which generally focuses on a defendant's lack of honest belief of truth. Same kind of idea. The focus is on what a defendant thought, not what defendant may have thought afterwards. So the crime or not occurred at the time. What matters is your knowledge at the time. So did you later learn that it wasn't true? Well, then it wasn't false when you wrote it, or it wasn't a lie, at least, when you wrote it. Now, maybe you have some obligation to update the record. So that's a whole nother issue, right? Maybe the relevant law imposes on you a duty to keep things up to date, but it wasn't a lie when you said it. If you later learned you were wrong, well, that doesn't make it a lie retroactively. That's not how that works. Even if, holy shit. Me. Mm, excuse me. Oh dear. Okay. Even though the phrase usual and customary may be ambiguous on its face, such facial ambiguity alone is not sufficient to preclude a finding of their own knowledge. So while the phrase may be ambiguous, if you understood what it means, you're guilty. So yes, maybe it's possible that someone didn't know, but you knew. So whatever might be true of someone else's confusion, you weren't confused. Get wrecked. Respondents make three arguments to support the theory, but the court finds none to be persuasive. First, the ambiguity of the phrase usual and customary does not by itself preclude a finding of the knowledge element under the relevant law. Even if the phrase is ambiguous, respondents could have learned the correct meaning. Instead, they argued companies received notice the phrase referred to discount prices, comprehended those notices, and then tried to hide their prices. So, yeah, you knew, so it doesn't matter. Second, the company's reliance on a different case's interpretation of knowing and reckless is misplaced because that case dealt with a different statute with a different mens rea. In any case, that relevant case did not purport to set forth purely objective safe harbor. So in a different case, when we came to the idea of knowing, we might, as it relates to that particular case, talk a little bit about the objective for reasons that would be relevant to that particular statute. So as always, when we're trying to interpret statutes, we try to interpret them within their own terms. So in that particular statute, maybe we brought in a little bit of the objective because that particular statute would require it. But we weren't trying to speak to what knowledge meant globally. You're trying to take the specific and apply it to the general. And no, that's not how this works. Nothing that the relevant law sets forth suggests that one should look to the facts or legal interpretations the defendant neither knew nor had reason to know at the time they acted. So, no, not so much for you. Finally, the respondents contend their conduct is not actionable according to common law fraud incorporated by the relevant statute because common law fraud does not encompass misrepresentations of law. Well, I suppose that's true because fraud is relating to facts, not law, right? Fraud is all about I lied to you, or I withheld facts, not about law. But basically, we're trying to argue ignorance of law here is basically what we're trying to do. Yeah, good luck. Respondents then posit their alleged claims were false only because their claims falsely turn in part upon the meaning of the phrase usual and customary, which they argue means the claims would be false only as misrepresentations of law. We're trying to argue ignorance of the law over here right now. You can imagine how well this is about to go. But that does not follow. Even assuming the relevant law incorporates some version of the rule, respondents did not make a pure misrepresentation of law. They did not say, for example, this is what usual and customary means. Rather, they made a statement that implied facts about their prices, essentially saying, this is what our prices are. So they didn't say, oh, here's how we're interpreting usual and customary, and given that interpretation, here's the price. They just said, here's the price. Petitioners thus make out a valid fraud theory even under a common law. So your ignorance of the law excuse is working just about as well as you would think. Thomas delivers opinion for the unanimous Supreme Court. Oh, thank you, Jane. That's very, very kind of you. Thus, that brings us to the end of the case of United States in the form of Shoot versus super values. Shoot over here is the United States because the United States allows them to be the United States. They are a private party representing a harm that occurred to the United States in their view. What they think happened is that SuperValue lied to Medicare and Medicaid about the price of their medications because they really had a coupon that they offered to everyone, but they didn't really tell Medicaid about it very so much. SuperValue is over here like, what matters is what like an objective person would think when it comes to lying. And the Supreme Court's over here like, no, that doesn't make sense. That's not how knowing works. What matters is what you know. So, no. So Shoot over here can continue pretending that they're the United States, living out their dream. I am the United States, bow to my will. And they can continue suing SuperVal for the money relating to the fraud, assuming all this, of course, is true, because of all this will have to be teased out at some sort of trial, because we obviously ran into issues as it relates to legal interpretation. But now that we found out that SuperVal over here, you know, what knowledge means is what you know, unsurprisingly enough. Yeah, SuperVal and Safeway over here might have some problems. So we'll see how that all progresses. At least for a moment, that brings us to the end of discussion of this case. Push the button. Didn't change very much, but technically did change. Sometimes it doesn't change very much. Yeah, let's push it again. See if we get a more varied change. Yeah. All right, let's see what else we got. All right, let's do this one. Thank you, everyone, for being here as always. I really appreciate the 259 of you who are currently here. Thank you very, very much. Just a kind reminder, if you'd be so kind to please hit the like button and the subscribe button and all that stuff. It is very, very appreciated. And all those people who support the channel financially, endlessly appreciated. And to all our members, we do love all of our uncivilians. It is fantastic. Thank you very much for being here as we learn about all kinds of fun and exciting things. Fantastic. Let's learn a little bit more about stuff. Delta Airlines recently announced that it wanted to be a carbon neutral airline. Airlines, of course, burn a lot of fuel to do their airline thing. And Delta's over here like, we want to be carbon neutral. We're going to buy the carbon offsets. Aren't we a great company? Well, Delta over here is facing a lawsuit because the carbon neutral stuff is greenwashing. So a lot of these companies, when they're buying the things, what they're buying really doesn't really exist. So we'll pretend like we're trying to improve the environment, but we're not really. So we are misleading people by saying we're carbon neutral when we're really not. So Delta, the latest company to get busted by this attempt at greenwashing. Let's learn a little bit more about this lawsuit against this airline. A Delta passenger is suing the airline over its claim of carbon neutrality, alleging that the 3-year-old pledge is not real. Delta Airline isn't really offsetting its carbon emissions. They are really lying. The suit, which is filed in federal court, alleges that Delta's claim to be the world's first carbon neutral airline is a sham. Greenwashing refers to marketing spin that makes it appear that a company is environmentally friendly when really not. Rather than undertaking actual work of reducing carbon emissions, the complaint alleges that Delta is borrowing largely fabricated carbon offsets while continuing to charge a premium price to travelers who believe they're paying for environmentally friendly travel. So one of the ways that this sometimes happens is that there is a preserve that already exists. And sometimes they'll try to buy carbon credits. It's like we're keeping the preserve in place, but the preserve would exist regardless of the carbon credits. So they're not really buying anything, right? It's just pretending to buy something. Oh, we're maintaining the preserve. The preserve is going to continue no matter what. So you're not really buying something, or you're funding projects that already exist, or otherwise, not really doing things. So you're not really lowering carbon emissions. You're just pretending and doing this greenwashing. The suit, which seeks class action status, is the first to challenge a U.S. airlines, claimant claims, according to the plaintiff attorney. The climate crisis is, in a lot of ways, a consumption crisis. It is corporate supply chains and decisions that everyone makes and everyone participates in. As public consciousness is raised, consumers are trying to make informed decisions that mitigate impact, and companies are trying to capitalize on that by saying that they're a green choice. So nothing necessarily requires Delta to do this, right? They are doing this because they think it brings to them some market advantage, or they think it brings them warm and fuzzies, or for other corporate reasons. But they're like, well, if you're going to do this, you actually have to do it. You can't just pretend to do it, and that's what you're doing right now. So you're trying to lie to people and misrepresent them. The people who are suing adding, if you're thinking you're flying the world's most green airline and you're not, why wouldn't that be actionable? Well, if you're really being induced by that, at least in part, then maybe, because effectively it's fraud. Fraud in the inducement, right? We're lying to make ourselves seem differently than we are. So if you can show that you're choosing Delta, at least in part in this, and they're not doing that, then, maybe. Flying accounts for about 2% of greenhouse emissions, according to the International Energy Agency. So significant, notable, something perhaps we should look into, and Delta is lying about it. Delta, which did not immediately respond to comment, had told the Associated Press in a different comment that the lawsuit was without legal merit. Delta is saying that since March the 31st of 2022, Delta has been fully transitioning its focus away from carbon offsets towards decarbonization of our operations, focusing on our efforts to invest in sustainable aviation fuel. So maybe we were lying to you in the past, but we're not lying to you anymore. Or maybe we are. Who knows? That's what's going on. The person bringing the lawsuit told the news that climate change gives their own generation anxiety, and claims they were frustrated to learn that the climate claims, which made them more comfortable for paying for flights, might actually be based on lies. So they, were trying to do the right thing via their perception of the climate crisis in their own view. They are a market participant. They want to vote with their own money and their own feet. They care about the issue. And they say that they chose Delta at least part based on these promises. So maybe there's a claim there. The person who's suing saying they can't just claim neutrality if that's not actually true. To the extent it's inducing them to make purchasing decisions, that might very well be the case. Jules Buddha gives more memberships. Thank you very much as well, Jules, for your contribution. The lawsuit alleges that there might be thousands of other travelers out there who have maybe paid more for Delta flights because of this issue. So I'm suing on my own behalf and other people who might be similarly situated to this. Carbon offsets, which rely for paying on climate beneficial activity like reforestation, have emerged as a major part of many climate pledges. But a growing body of research has shown that these emission reduction benefits of offsets are dubious at best. So a lot of them are questionable in sort of whether they exist at all. And to the extent they exist, their efficacy is also questionable. For example, Delta's forestry and agricultural offsets for 2021 were certified by a vendor, according to the complaint. However, an investigation by The Guardian earlier this year concluded that more than 90% of the offsets have no climate benefit. So again, this same sort of problem, right? Delta buys these offsets that they say are certified, but an investigation showed that it's all built on lies, and perhaps Delta knew that. Most of Delta's offsets paid for projects that would have happened anyway without the investment. Another common problem with greenwashing, right? This would have happened no matter what you did, so you aren't really contributing. You're just trying to pretend that. A Bloomberg investigation last year found that dozens of large companies, including Delta, rely on these junk credits in order to make these claims. That does seem to be a bit of a problem for some of this, yes, to be sure. Even where the project is valid, there's no guarantee the offsets are permanent. For example, there's no assurance that a tree planted won't burn down in a forest fire, which will release its own carbon. So the degree to which the projects, even if they're real, are successful in a permanent way is perhaps questionable. Because of the concerns the suit claims, companies including JetBlue and Lyft have stopped using credits as a way to get out of this problem and look to reducing emissions in other ways. The reality is a lot of companies knew these offsets were questionable and didn't buy them and didn't advertise on it. This case is not just about climate change, it's also about fairness to the consumer, which, fair enough, right? Your ability to make decisions for yourself as a consumer is your choice. You should have the rights to buy products based on the terms you see fit. And whether you believe this or not is completely up to you. And if you want to make purchasing decisions based on that, you should. Incidentally, for what it's worth, I pay slightly higher in electricity than I have to because I am paying for green energy, right? My company gives me that option. It's like, would you like to pay this slightly higher rate for electricity? Because if you do, it means you're getting green energy. And I'm like, yes, I'd like to check the little box because I'd like to help support this. And if I found out that that wasn't really happening, I'd be a little bit irritated because it's costing me money. But I'm trying to do something I think is positive to try to induce some change in the world. And, these people are making similar decisions as consumers. So if we're being lied to, well, we all have a right to be a little pissed off. Tracy Peterson gives $20 to say, one, to pay for the gift membership. I evidently have to wait until my gift expires. Really enjoying the morning streams with my coffee. Thanks, Kurt. Moz in chat. Well, thank you, Tracy. That's very, very thoughtful as well. I appreciate it. That is very nice of you. A handful of lawsuits over the past 2 years have made similar claims, which Dutch airline KLM, French energy giant Total Energies, and a food company, Danone, also being sued for similar claims. US regulators are also looking into the issue, with the Federal Trade Commission in the midst of updating its guidelines on this issue. So, in order to make the marketing more fair, the Federal Trade Commission, of course, deals, among other things, with honesty in business advertisements. And so they're looking towards regulations that would define this so that, they are not allowed to lie about what they're doing. So, a lot of lawsuits and governmental action in this as well. Sorry, I was trying to hear something. I thought I heard something in my breathing, and I wanted to check it real fast. Gary Barnes, were I genuine about wanting feedback on my channel? Yes, if it's offered in a polite, respectful way, and you accept my answers to various suggestions. And even if I reject a rejection, even if I reject a suggestion today, I may think about it and do it later. So yes, I am willing to listen to your suggestions, but I want you to be respectful in your suggestions, and I want you to be respectful of the decisions I make, because it is my channel at the end of the day. And so yes, that would be fine. Also, if you're the person I keep banning, go away forever. I don't want to hear from you. You know who you are. Stop talking to me. Thus, that brings the Thus, that brings our attention to the end of the case of Delta being sued for the carbon neutral claims, as many other companies have been in the past. So, this has been an issue that has been percolating for several years. Other companies have been sued, Delta also getting sued for similar claims. So, the degree to which this lawsuit will be allowed to persist and exist as a class action, of course, is questionable for a whole bunch of procedural reasons. But the underlying issue is, of course, a problem. So, there's like a little wheezing in my there's a little wheezing in my breathing. Hmm, interesting. I need to redo the outro. I lost my train of thought. Hmm. Successful law tubers seem to talk with their viewers instead of at their viewers. Well, I'm not 100% sure what the difference is. I mean, I do respond to comments and respond to chats, and I try to talk with you guys. Um, Obviously, when I'm reading the stories and streaming, I'm talking about the stories, but I try to talk to you guys as well. Anyways, I'm not done with the story. I'll push the button in a second. I'm still trying to do the outro. Thus, that brings us to the end of the case for the moment, with Delta dealing with this carbon neutral offset lawsuit, a lawsuit that other companies have faced in the past as part of this problem of greenwashing, where companies are buying things that don't really exist. The projects don't really exist. They continue anyway without the company's involvement, and other problems with greenwashing. The federal government is also looking into this, as other governments have looked into this for the same reasons, and all the rest of it. So, something that's obviously progressing, and we will see how that all progresses as green energy becomes more and more important to many consumers. And thus, for the moment, that brings us to the end of attention of this case. Push the button. Push the button. Yeah. Let's see. Okay. Okay. Any thoughts on the Travis Rudolph trial? Not in particular. I heard it's not going very well for the state, though. I heard they're kind of bungling it, but I don't have any particular thoughts on it. In Prince Harry and Meghan Markle news, Prince Harry's admission records to the United States may be exposed as there is a lawsuit over how he became part of our United States and when he immigrated here through customs and looking at his visa. So maybe Prince Harry did a bad, and there is an attempt to expose the records from the US government to see if perhaps the US government knows some things that perhaps they're sitting on, perhaps in an effort to try to shield the royal family from some embarrassment. So let's see what's going on with this lawsuit as it relates to the royal couple. Let's get started with this. The Heritage Foundation is taking the federal government in court in an effort to get records related to Prince Harry's visa application released, questioning whether the Department of Homeland Security acted properly after he admitted that he had used drugs on both US and foreign soil. So, of course, you want to come to the United States, you need permission from the United States. We're going to ask you some questions. Some of those questions might concern your drug use. And if you're doing drugs, perhaps we won't let you into the United States or we'll kick you out of the United States. So we can't help noticing that you admitted to the drug use. We can't help noticing that this would perhaps be normal grounds to not let someone in or expel them. And we can't help noticing he's still here. So what's up with that? We'd like to see the records. The Heritage Foundation and Department of Homeland Security will appear in federal court over the Freedom of Information Act lawsuit, FOIA, to force the release of the records, given widespread interest on specific issue of whether Department of Homeland Security acted and is acting in a way that shows appropriate equal treatment under the law. Of course, so far, Department of Homeland Security over here has declined to release the records. But do they have a valid basis to decline to release them? Unclear. In the complaint, of course, Heritage Foundation is seeking to compel the FOIA and to see information relating to DH's decision to both admit him and allow him to be here. Did you make the right decision in letting him come? Did you make the right decision in letting him be here? Has he broken the law? What's up with that? Widespread and continuous media coverage has surfaced over the question. Homeland Security properly admitted the prince in light of the fact that he publicly admitted to essential elements of drug offenses in both the United States and abroad. United States law generally renders a person inadmissible for entry into the United States under these circumstances. Intense media coverage has also suffered. Intense media coverage has also surfaced as to whether they may have improperly granted the prince a waiver to enter the country on a non-immigrant visa, given the histories of admissions to essential elements. So, did you follow the law, Department of Homeland Security, when it came to this, or are you treating the specials special? We'd like to know more. In his memoir called Spare, Harry wrote, "Of course, I've been taking cocaine at the time. At someone's house during a hunting weekend, I was offered a line, and since then, I've consumed more." He's also recalled taking magic mushrooms at Courtney Cox's home in Los Angeles. "We spotted a huge box of black diamond mushroom chocolates," he wrote. "Someone behind me said they were for everyone. Help yourself, boys. My maid and I grabbed several, gobbled them, washed them down with tequila, and later recalled hallucinating in the bedroom." The federal government, in response to the lawsuit, questioned the merits and suggested the plaintiffs had not demonstrated harm in seeking an injunction. So the injunction issue, maybe not. Maybe they don't have standing for that, but they do potentially have standing on the FOIA. So can we force the US government's hand when it comes to the immigration? Probably not. Can we force discovery of the records? A different issue. US Customs and Border Protection initially denied the request for records because they did not provide written authorization indicating consent for them to be released. So we're trying to claim Privacy Act over here, basically. So that's what we're trying to hide behind. All right. Prince Harry and his wife Meghan over here moved to California in 2020 and also announced they would step down from the role as senior royals, whatever the hell that means. The hearing related to the FOIA will be heard before the courts in Washington, D.C. We want privacy. We want privacy. We want privacy. Okay. I'm not sure what's up with this sudden wheezing. It felt like I pulled a muscle in my throat. Is when I said like, oh shit. Because it felt like I stretched my vocal cords. I suppose vocal cords are a muscle and can get a sprain. It felt like I sprained felt like I put too much pressure on my vocal cord, and since then I'm sort of wheezing. So I'm wondering if that's what's going on there. Anyways, carrying on. Thus, that brings us to the end of the case dealing with Meghan Markle and Prince Harry as it relates to emission records to the United States. Prince Harry is admitted to doing drugs, both here and abroad. That would seem to potentially exclude him under relevant US law from the jurisdiction of the United States because of the drug use, both here and abroad. And, Department of Homeland Security, we can't help noticing that he's still here. So what's up with that? We'd like to get access to the records. We'd also like to get an injunction, which we're totally not going to get, relating to kick him out of the country. We can't force Department of Homeland Security's hand because we don't have standing, but the records maybe we can get. So how that relates to privacy issues, Privacy Act, FOIA, and all the rest of it, I don't know. But a DC court is going to hear all that. And that, for the moment, brings us to the end of discussion of this story. What else we got? Push the button. Thank you, Dragon Book. Chili's baby back ribs. Chili's baby back ribs. Barbecue sauce. Chili's baby back ribs. Chili's baby back ribs. At this point, I'm going to have to start making my shows shorter just for my own sanity because the editing takes so long. Dude, we're going to have to make I don't know. Or I have to do more editing on the weekend. I have no desire to ever wear a fez or a top hat. No, I'm quite fine. And also, it's not strictly speaking a Stetson. It's custom made hat. Respect the hat. Yeah. Oh no. Oh no. We have to make streams shorter or something because I'm getting a little bit of burned out doing this. We're into week 6 of this, and I'm getting a little bit burned out because of how much work it takes to put all this together. Okay, let's continue going. All right. In We Take Our Chili, very serious news. New Mexico chili is at the center of New York lawsuit because maybe the peppers aren't from New Mexico. We take our chili very, very seriously over here. As a Texan, I understand as well. We got to take that chili seriously. And if we're going to say it's New Mexico chili, damn it, it better be New Mexico chili. Where's that salsa made? New York City? All right, so let's learn a little bit more about the New Mexico chilies and where they're really from. Where peppers are grown matters, according to this new lawsuit in New York. Just like Idaho potatoes or Florida oranges, New Mexico chili means New Mexico grown and processed packed chili peppers, says the attorney. It's really not complicated. We are very serious about the chili. The class action lawsuit filed Monday alleges that Florida-based Batica Spices deceives customers by selling fraudulently labeled packages of New Mexico chili. The packages appear to include small dried peppers and clearly say New Mexico on the label. The lawsuit notes the indigenous style artwork on the packaging could also be seen as an indicia of where it's from and false advertising. Here, apparently, are the peppers in question. Badia, New Mexico chili. There are some chilies. We say they're New Mexican, but are they? Dun, dun, dun. While not directly referenced in the lawsuit, some New Mexicans argue the most egregious error is the spelling of the word chili. We are not happy with that. We spelled it C-H-I-L-I when it should have been C-H-I-L-E because we're referring to the pepper, not the food. Despite the clear label, product information on the company's website reveals the peppers come from Mexico, not New Mexico. Dun, dun, dun. You know, there was a famous series of articles. I think it was in Reader's Digest called Our Forgotten State, which was all about New Mexico. And maybe it's still going because people confuse New Mexico for Mexico all the time. And there's a reason, if you ever see a New Mexico license plate, it says New Mexico, USA. There's a reason it says New Mexico, USA on their license plates, because people think New Mexico is part of Mexico. It's only been a state for the last 100 years, and people are still making this mistake. New Mexico is part of the United States. It's a state, people. I know it has the word Mexico in it, but it's not part of Mexico. Also, spoiler alert, New England is not part of the country of England. Wow. This case is based upon a regular person, referencing the woman featured in the lawsuit. The person goes to the supermarket and they see a product called New Mexico chili peppers, and they would think New Mexico. The lawsuit says the woman bought them, believing them to be from New Mexico. It's not clear how the woman learned they weren't authentic, but the suit says they paid $6.99 for the 6-ounce bag. The New Mexico chili peppers were still on sale on the company's website for similar prices. It's not fair to consumers and not fair to New Mexican chili farmers and growers of generations who have seen their business withers, unfortunately, because of excess imports from other countries. Although, pull an average American off the street and they might think that New Mexico is part of Mexico because they've only been making that mistake for the last 100 years. It literally says New Mexico, USA on their driver's licenses. Sometimes even immigration screws this up. It's like, why don't you have a passport? Sheehan believes the packaging is unfair, using the prestigious New Mexican reputation to sell these inferior Mexican peppers. The lawsuit alleges it violates consumer protection law to shield from fraudulent advertising. I mean, it does say New Mexico in pretty bold letters. I am feeling the rage all the way over here. Yeah, also New York, not part of York. Also New Hampshire, not part of Hampshire. Deep thoughts. The lawsuit is demanding that the company pay more than $5 million. They say the amount is based on likely sales of peppers and damages. It's not clear how many stores are selling these godforsaken misleading peppers. These cases, like the particular case, are only the way consumers can say that this shouldn't happen. I am feeling the rage. The New Mexican Chili Association, which apparently exists, says that fraudulent labeled chilies are a major issue for the chili industry. So we are very, very serious about protecting the New Mexican born chili. As the marketing and brand of New Mexican chili has grown, we've seen this problem grow exponentially, says the executive director of the agency or the association. It's significantly cheaper for businesses to purchase chili out of Mexico because it's less cost and then turn around and slap the name New Mexico on it. How very much dare they? How very much dare they? The guy who works for the association says the products are sold at equal or higher prices than authentic peppers. He says those profits should be coming back to the farmers of New Mexico. New Mexican state lawmakers passed the Green Chili Advertising Act in 2011 to combat this issue. So the New Mexican government, straight to the fire, said, damn it, we want to make sure these chilies are New Mexican. The guy who fronts the association says the law inspired New Mexico certified chili trademark, which identifies products made with authentic New Mexican chilies. The guy believes federal law may be needed to combat this because of how much this is going on. This is great. We're hopeful in the near future some sort of legislation to protect the New Mexican chili will come into light. New Mexican is a regional name, damn it. It's like champagne. It has to come from Champagne if you want to call it Champagne. It has to come from New Mexico if you want to call it New Mexico. In the short term, we're asking consumers to help us by looking for that special New Mexican certified trademark. Thus, that brings us to the end of the case of the New Mexican chili. And although I am a Texan, I share my brother state's outrage at this. This is completely unacceptable. We can't have the misleading chilies. That is an abomination. If I want my chilies from New Mexico, damn it, they better be from New Mexico. And the fact that this company over here is selling me peppers from Mexico instead of New Mexico, for shame, sir. For cattle rustler, you're an enemy to the people. That is how bad you are. Hostis humani generis. You're an enemy to the people of all mankind. Universal jurisdiction. Because of your outrage. That's where I'm at on this. How about you? And that, for the moment, brings us to the end of discussion of this story. Push the button. Thank you very much. Great. All right, let's do some more stuff. Hostis humani generis, an enemy to the people of all mankind, is a concept invented by the Romans. Universal jurisdiction. Everyone has the right to prosecute them. we don't need no specific law. You're an enemy to all people everywhere. Universal jurisdiction. Good times. Ah, Lord. It's like kind of like war crimes, but a much older concept. We originally invented it for pirates because the pirates are operating on the seas, not necessarily within any country's jurisdiction. So the Romans invented this concept, hostis humani generis, which is basically we don't care. We don't care that you're not entering. We're not within our borders. You're an enemy of all mankind. So we have the right to prosecute you everywhere. We will. It doesn't matter where you're doing your piracy. You're an enemy of all mankind. So some legal concepts for you for the day. Great. I don't think I said better. I think I said older than war crimes. I don't think I said better. But either way. All right. In your home assistant device may be listening to you and keeping your messages recorded for longer than you think news. The FTC and DOJ have charged Amazon with violating children's privacy laws because they keep Alexa voice recordings forever and don't delete the information even when asked. So they're keeping your kids' voice records and your records and won't delete it, and they're getting sued for that by the federal government. So let's learn a little bit more about that. The Federal Trade Commission and Department of Justice are trying to require Amazon to overhaul its deletion practices and implement privacy safeguards to settle charges relating to the Child Online Privacy Protection Act, which was passed by Congress to grant additional protection when it comes to children and children records and how we advertise towards children and other aspects as it relates to children on the internet. The government argues that the company deceived parents and users of the Alexa voice assistant about its data deletion practices. According to the complaint filed by the government, the Amazon has prevented parents from exercising deletion rights under the relevant law, has kept sensitive user voice information and geolocation data for years, and used it for its own purposes while putting the data at risk of harm from unnecessary access. So, yeah, we're keeping your voices, we're keeping your information, we're keeping it forever. We're not deleting it even if asked, even for the children. Yeah. Amazon's history of misleading parents, keeping the recordings indefinitely, and flouting deletion requests violates the federal law and sacrifices privacy for profits, according to the FTC's lawsuit. The relevant law does not allow companies to keep children's data forever for any reason, and certainly not to train their algorithms. Under the proposed order that was also filed alongside the lawsuit, Amazon will be required to delete inactive children accounts and certain voice recordings and geolocation information and be prohibited from using the data to train the algorithm. The proposed order would have to go into effect by the federal court in relation to the proposal. According to the complaint, Amazon prominently and repeatedly assured its users, including parents, they could delete voice recordings collected from the assistant and the geolocation information also collected by the app. The company, however, failed to follow through when it kept this information for years and used the data without permission, even in response to deletion requests, using it to help improve the Alexa algorithm. Amazon, which of course is one of the biggest retailers, collects vast amounts of data on consumers relating to geolocation data and voices and other things from other aspects of their company. The company claims that its service and devices are designed to protect privacy. We see how well that's going. And parents and other users can delete the data and recording, although not so much, apparently. According to the complaint, Amazon also offers the devices and services in a way that are targeted specifically towards children and collects data, including voice recording, from the children. Amazon retained the recordings indefinitely unless they requested to be deleted, and even where requested, not so much. The relevant law requires, among other things, that an operator of a commercial website or online service that is directed at children at 13 years of age or under notify parents about the information they collect, obtain consent, and allow them to delete that information at any time. In addition, such service is prohibited from retaining information collected from children under 13 for longer than is necessary to provide the service. So they can't maintain it. They can only keep it as long as they're using it, but not any longer, and not so much with any of that. Amazon claimed it retained the data in order to help it respond to voice commands, allow parents to review them, and improve speech recognition, according to the complaint. Amazon says that children's speech patterns and accents are different from adults. So unlawfully retained voice recordings provide Amazon with a database to train to understand children, benefiting its bottom line, but at the expense of privacy. So we did it for your good, the consumer. Why don't you understand how much good we're doing you, says Amazon. The FTC says the company failed to put in place a system to ensure it honored data deletion requests, and even where they discovered the failure internally, Amazon did not actually fix the problem. So Amazon was aware of this internally and did nothing to solve the issue, because why would they? The proposed order suggests that Amazon pay a $25 million civil penalty, which again, we will probably find out of our sofa cushions at our corporate headquarters. It would also prohibit Amazon from using geolocation voice information and children voice information subject to deletion requests, require the company to delete inactive accounts, require Amazon to notify users of the action, require Amazon to notify users of retention and deletion policies, prohibit misleading policies, and mandate the creation and implementation of a privacy program relating to geolocation data. Okay. Thus, that brings us to the end of the case of the FTC and DOJ charging Amazon with various privacy violations in relating to the Alexa app maintaining records, even when they're asked to delete them in violation of federal law. The federal government has proposed a settlement relating to this that will, pinky swear Amazon to better practices, and I'm sure they're going to get right in on that. So that looks like that's going to go through. That appears to be the resolution of the issue, and that, for the moment, brings us to the end of discussion of this case. Push the button. Yeah. Florida man. Thank you for being a friend. Thank you for being a friend. All right. We're grinding out here, man. We're grinding. We're grinding every day, man. And we are trying to make this really as best as we can, and make this channel as best as we can, and make the stories as good as we can, the thumbnails as good as we can, the titles as good as we can, the video descriptions as good as we can. The stories we pick, we try to make them good. We try to make everything as good as we can. And I only am able to do this with your support. And we are now starting, what was it? Maybe it hasn't been that long. Was it a week ago? It might have been. Starting like a week ago, we started doing shorts on the regular and exporting that all the places to try to help drum up additional attention to the channel. So, you know, good times. And I appreciate very much the super chats, and I appreciate very much the memberships. And I appreciate very much everyone who helps financially support this channel to try to make it grow and try to make it the best channel we can possibly make it be. You guys are awesome. Okay. Mm, great. Law and Lumber's here. Thank you, Law and Lumber is here. Law and Lumber, Rob and I had a very nice chat about nothing in particular last night, because I just wanted to call him just to, have a friendly conversation last night. And we actually got into some deep topics along the way, which was also nice. So I appreciate that Law and Lumber's here. You're a good friend, Rob. You really are. And I appreciate that you support the channel and support everything we're trying to do over here. Great. All right. For today's Florida man, An MMA fighter has the fight of his life as he wrestles a 10-foot alligator at an elementary school. We must save the children from the alligator, Florida man says, and steps right into the fight. The ring, at the poolside, the riverside, the lakeside, at the elementary school. One gator, one Florida man, MMA versus elementary school. Let's get started with this. God, my eyes are attacking me. Please stop. Please stop attacking me, eyes. Please. 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 God damn it. Okay. Okay. A Florida MMA fighter had the match of a lifetime when he wrestled the 10-foot alligator in front of 200 cheering elementary school students who thought that he was just the most Florida man hero they have ever seen in their life. And there is apparently video of the encounter. The amateur fighter took the unusual opponent in a parking lot near the school as people gathered to watch. We got there. I walked through the gate and boom, there it was, just ready to go, right there in the parking lot, and just had to get the job done. He told the local station, here is a still from the gator fight. Man versus gator, parking lot, children, cameras, lights, yeah. The individual dressed in a muscle shirt grabbed the large gator by the tail and attempted to drag it as onlookers screamed at the reptile escapes and snaps according to the video. As the beast broke free, the local veteran armed himself with a pole, which he's able to pull around the alligator's neck. The animal rolled in circles, fighting the restraint as the crowd screamed while closely watching the man versus beast matchup. I felt like Batman, you know, for real, the man said. Wow. He feels like Batman. That is great. With catch pole still available, the MMA fighter jumps onto the animal's shoulders as he and multiple Jackson firefighters sit on the reptile to try to hold it down. A lot of fighters will understand that once you go to the cage, you get nervous. But once the cage door closes, you gotta be focused. And honestly, that's what I remember from that night. He got on top of the gator. Are we trying to ride it to a submission hold? Unclear. Alligators apparently are about 1.3 million of them in the great state of Florida. The Floridians can report the nuisance gators over 4 feet in length that poses a threat to people, pets, or property in order to have licensed trappers come out and remove them. This guy has a license? Outstanding. The reptiles that are removed are then euthanized so they don't return to locations where they're captured to cause disruption to other alligator social structures in the area. Okay, you know what we have to do now? We have to find the video. Hold on. I didn't know there was video. Hold on. Oh, yeah. No, I don't want, I just want the damn video. Just give me the video. I don't want the news report about the video. Give me the video. No, I don't want the news report. Give me the video. I don't want a news report. Just give me the damn video. Am I not going to get the video? Is that what's happening? I'm not getting the video in my life. Is all I get 25 seconds? Where's the rest of the video? I want it all. I don't want 25 seconds. I want the whole thing. I don't want 25-second bullshit. I want the whole thing. Is this TMZ? No, that's just an interview. Why can I not find the actual video? I might run for judge someday. I'm just not eligible right now under Texas law. But I might run for judge someday. Thank you, just me. I think I have to be a lawyer for 10 years before I can run for judge in Texas, or for Supreme Court anyway. So I can't find the actual original video. All I can find is news stories about it. I want the actual original video. How hard is this? Apparently very hard. I can't run for United States Supreme Court. I have to get Joe Biden to appoint me. Feel free to call 202-456-1111 and tell Joe Biden that he should appoint Kurt Mueller to the US Supreme Court. Well, I can't find the original video and it's pissing me off. All I'm getting is news reports about the video and I can't find the original. And it's pissing me off. Yeah, it's just giving me back the same original video. So I guess we will go without video today. All right. Thus, that brings us to the end of the story about Florida man fighting the gator, and with the elementary school students watching. So Florida man always to the rescue every time, and no exception today, with this wonderful Florida man story, wrestling the alligator in the parking lot and then putting it in a submission hold to be taken away by firefighters. Wow. All kinds of exciting. So all that wonderful stuff is happening in Florida. And that, for the moment, brings the end of discussion of this story. Okay, well, that will be the end of the stream now. All right, so I need to sign off. Okay, you sent me gifted members and super chats. Thank you very much. Sandy. Corey Richens case. Corey Richens again, isn't that the fentanyl one? Yeah, that's the fentanyl one. We might cover that. Okay, I'll put that on my radar. Melissa gave me a super chat, $4.99. Jules Buddha gave $50 super chat. Tracy Peterson gave $19.99. Alan Parker, 20 gift memberships. Kit Kat, 5 gift memberships. Sandra Ramirez, 5 gift memberships. Jules Buddha gave another 20 gift memberships. Law and Lumber gave 20 gift memberships. Jonathan gave a $10 super chat, and Just Me gave a $10 super chat, all of which is endlessly appreciated. Thank you. You called and left a message? Excellent. I mean, I do actually know the number of the White House opinion line off the top of my head. If you want the White House switchboard, it's 202-456-1414. It's good to know these things. Aussie says for $5 Australian, I love your Florida Man stories. I once played the oncology waiting room last week. Got us all laughing. Oh, that's really cool. I'm glad to hear that. That's really cool. And the White House opinion line is 202-456-1111. So it's nice. It's helpful to know these things. It's great. It's a great number to give out when you don't want to give out your number. Like if someone like, you know, it's like, you're at like a convenience store. It's like, can I have your number? It's like, yeah, 202-456-1111. Call the White House. Tell them all about it. So, so women, if you ever don't want to give out your number, you want to give it a fake number, there's a good one to give out. Anyways, I'm going to sign off for now. I have some editing to do. And I need to also rest my voice because I think I strained it slightly. And theoretically, I need to go to the gym at some point. Not sure when that's going to happen. But I've ever called it? Sure. Why not? Anyways, I'm going to sign off for now. I hope you have a great day. Till later, my friends. Cheers and goodbye.